Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam. Pam, today we're going to talk about women in business, and particularly women at the top of the business pyramid. And when you think of the top of the business pyramid, most people are thinking of CEOs like Tim Cook of Apple.
Or Tim Apple of Cook.
But there's a group that in some sense is above those CEOs. That's a board of directors who can hire or fire them. And most CEOs tend to be male. What do you think most board of directors are?
I'm going to just take a wild guess, Joe, and say that they're mostly men, too.
They're mostly men, too. But California is trying to change that. They passed a new law requiring that boards have at least one woman on them for many of the publicly traded companies that are going to be familiar to our listeners out there. And in time, more than one woman on them. And today we're going to be talking about that law.
Well, and we couldn't have two better guests to have with us to discuss the law. Joe?
That's right. One of our guests, Gail Harris, is a Stanford law graduate who's had a terrific career in law. She's been a partner at the law firm of Simpson, Thatcher, and Bartlett, and that's one of the Tony white shoe firms of New York. And she's had a lot of experience on board. She's a lead director of Evercore, an independent investment banking advisory firm, where she also serves as chair of the Nominating and Corporate Governance Committee and is a member of the Audit Committee. And one of the things we're going to be finding out is what all that means.
And she hasn't just been on those boards. She was also on the Stanford board as well. And so, she's had a lot of experience with boards. And we also have with us one of our colleagues today, Joe Grunfest, who's the W.A. Franke Professor of Law and Business here at Stanford. He was one of the founders of the Rock Center for Corporate Governance here. He's been a commissioner on the Securities Exchange Commission. There's really no one in business law today that knows more about boards of directors. And one thing about Joe is he doesn't just teach, he also does. He has been on boards of directors as well as studying them.
Welcome, Gail and Joe.
Pleasure to be here.
And Joe, you're a repeat guest, so
I'm a recidivist.
You're a
Yes,
recidivist here. We occasionally let you out for good behavior. Welcome, Gail.
Thank you. Glad to be here. It's an honor.
Well,
oh, no, I was just going to say, Gail, a lot of our readers, they've heard of boards of directors, but they probably don't know what they actually do. And if you could just give us a little bit of a sense of, as a member of a board of directors, what is it you're doing, and why does it matter who's on those boards?
Well, boards have a responsibility, obviously, to their constituencies, and I would say it's the shareholders among other constituencies, like employees, et cetera. But essentially, the board has the duty of oversight and advisory responsibilities. So we don't manage the board on we don't manage the company on a day-to-day basis. Our main duties, we hire the CEO, we plan for succession for that CEO, we participate in developing the short-term and long-term strategy of the company, we look at risk management, and, I think what's most relevant today is the board sets the tone. It is set at the top, and that's the tone for ethical standards, integrity, reputation. It's everything that the public actually should care about and that we read about in the newspapers, and that is the job of the board.
So when the public sees a CEO at the top, in some sense he or she's at the top. In some sense it's the board that's setting the tone. And tell us a little bit about women on the board. Are you often the only woman on the board, Gail?
I would say that for most of my career, I've been the only woman in the room. So going back, it's much better today. But certainly I was the only woman on the boards that I am on for quite a while. At Evercore, where I'm the lead director and chair of nominating, we now have 4 women on the board, which I'm extraordinarily proud of. And that was in large part because we also have a key executive management group that wants to have that diversity.
And can you give us a little sense of what difference you think the diversity makes in how either a board makes its decisions or how it sets the tone for what the CEO and the senior executives are going to do?
Well, I'll say it's interesting, but we'll see what you think. I've seen this being the only woman. I've seen this being having 2 women on the board, 3, and now 4. So I think I can make a comparison. And I would say that it changes the tenor of the conversation. The boardroom is definitely a different place, and when you hit 3, I had read that, but I wasn't sure I really believed it. I think 3 really is a critical number. Women really, I don't want to say generally think differently, but I find women are very much team players, are very supportive, but also question. On the boards I'm on, they will raise a lot of the tough questions, and they're not afraid to challenge the CEO. Now, on the boards, the men aren't either, but I do think at times there are different sensibilities in terms of maybe risk appetite depending upon where they've come from. And all of these generalizations obviously are generalizations. But I can tell you one quick story if this would help, and that is I did a panel in front of all of the women in a particular company. On the panel were 2 other female directors who had a fair amount of experience. The panel was moderated by a female partner in that firm. One of the questions I asked, in the middle I said, has anybody in this room ever been in the position where they've made a comment and 5 minutes later a man made that comment and suddenly it's an aha moment and the comment is fantastic? Every single person, including all of the panelists, raised their hand. Everyone. And it wasn't that it happened 10 years ago, it's that it continues to happen. When you have 3 women in the room, suddenly the women are saying, oh, so-and-so just said that, and I agree.
So this is Stanford Legal, and today we're talking about boards of directors and the differences diversity can make with Gail Harris and with Joe Grunfest.
You know, Gail, your story reminds me of an old New Yorker cartoon, which maybe you've seen, and it's an all-male boardroom with one exception, and the lead figure says, that's a great point, Mrs. Smith. Perhaps one of the men would care to make it.
Yeah, so art follows life. Art follows life. So, Joe, you've been on boards as well. Have you noticed a difference in the tenor of boards you've been on that are all male versus boards that are of mixed gender?
Absolutely. Let me expand it a little bit beyond that. Gail never has the ability to observe the phenomenon of going from 0 to 1. So Gail has never been in the room where there's no women in the room. I've been in situations where you're part of a collective decision-making group, whether it's a board or not. It's all male, and then you add a woman, and in my experience, the change is remarkable. And you can summarize it very simply by saying there's a whole bunch of locker room stuff that never happens again. And not only does the tone and tenor change, but also the thought process changes. Because men will behave differently in the presence of women. And shorthand, I simply describe it as a civilizing influence. I realize that's overbroad in a sense, but that's my personal experience.
So one thing, I want to go back to something Gail said right at the beginning about, the constituency of a board is the shareholders. So it's maximizing the value of the corporation in a sense. So if it's actually better to have women in the room, why haven't we seen more boards with more women on them?
Well, first, the proposition that it actually increases shareholder value to have women on the board is I think, empirically contestable. All right? There's literature out there that purports to find that relationship. There's a lot of literature out there that says, no, it isn't there. It's the result of data mining. It's not statistically significant.
Is there any, let me just ask you, is there any data that suggests putting a woman on your board decreases the value?
No. Let's put it this way. Or if anybody's ever run that regression, they haven't been so bold as to publish it. But if you were to ask me to summarize the data, it's basically a wash, all right, which for many different empirical reasons is what you would expect. But that's not the reason not to put women on boards. There's so many positive and important reasons to increase women's participation and also minorities. I mean, we haven't spoken about the underrepresentation of African Americans, of Latinx, of other groups on corporate boards, and for a wide variety of reasons, entirely unrelated to stock price performance. I think it's essential that boards become more representative of the way America looks today. And it's not going to hurt stock price performance. It'll improve relationships with employees. It'll help with customers. For a variety of statistical reasons, it'll be hard to find that relationship in stock price. But that doesn't mean you shouldn't do it.
Well, I don't think any of us are going to argue against the proposition of putting more women on the board. Let's talk about the law for a minute, because the law is a little bit unusual. You don't have another law that I can think of where a state says to a private party, here's a quota, it is a quota. You have to have some diversity, and we're going to define it for you. And I think in the California law, it starts with one woman on a board, and I believe it applies to companies that are headquartered in California and also incorporated in California. And that's kind of an odd term for people to get their heads around if they're not in the business world, that you can be headquartered somewhere and incorporate it somewhere else. But I think as a practical matter, the law is going to apply to a lot of companies because a lot of companies have their headquarters in California. And Joe and Gail, is that a correct assumption?
Well, the short answer is yeah. And where this is leading, from my perspective, is fascinating because the California legislation, which requires that every corporation headquartered in California, even if chartered in Delaware, which is the vast majority of the California headquartered corporations, have to have at least one woman director by December 31st, 2019, and that date is passed. And if you've got 5 directors, you have to have at least 2 women. And if you actually have 6 or more directors, you have to have at least 3.
This is Stanford Legal, and today we're talking about diversity on corporate boards with Gail Harris and with Joe Grunfest. Joe?
And so we've got this sliding scale that a lot of companies are going to have. One thing to pick up on, Joe, let's just explain to people when we say chartered in Delaware, and I use the word incorporated, tell us what that really means.
That means that a corporation can be located, in effect, anywhere in the world, and its creation, its organic documents, can be governed by the laws of Delaware or California or any of the 50 states in the United States. And the most common pattern, for a wide variety of reasons, is that corporations that have their headquarters here in California, whether it's Facebook, Google, Uber, Lyft, the vast majority of them, more than 90%, wind up being chartered and created under the laws of Delaware. So you can have your headquarters in California, but you can be governed by the corporate laws of Delaware, and that raises an important question about the constitutionality of the California legislation.
And that's because typically California would be respecting Delaware law, which has rules governing what kind of board you have. But in this case, it's as if California arguably is rewriting the Delaware law or encroaching upon it. Is that right, Joe?
Absolutely right. A+, Joe.
I've taught this subject before.
Yeah,
it's cheating.
Gail, you had something you wanted to say about that.
Joe, it's curious to me, though, why hasn't this law been challenged on those grounds? Why do you think people are stepping back and not doing that? Is it public perception?
Well, I actually think you're asking a much more important and much more profound question. You know, as I look at this legislation that's technically called SB 826, I would describe it as the most successful unconstitutional law in United States history. Now, why do I think this law is successful? The answer is it's working. It's causing many corporations that are headquartered here in California, although they're chartered in Delaware, not to raise any of these constitutional objections, but instead actually to put more women on their boards. Here's one simple statistic. As of the date that SB 826 was enacted, there were 93 California corporations that had all-male boards. By November 22nd of last year, that number was down to 17, and I wouldn't be surprised if it's essentially zero by 12/31, meaning that everybody has come into compliance. None of those corporations appear to have said, we're not going to put any women on our boards, all right, because we think that it's unconstitutional. And it's unconstitutional, in my view, for at least two different reasons, and I hold this view even though I strongly think we need to have more women and minorities on boards. First, it violates the Internal Affairs Doctrine, and second, it violates the Equal Protection Clause of the California and U.S. Constitutions.
Could we start with the thing that's likely to seem less familiar to our viewers? In about a minute, can you explain what the Internal Affairs Doctrine is?
I'm on the clock. I'll give it a shot. It's in a certain sense, it's really simple. If a matter relates to the internal governance of a corporation, for example, the rules for electing directors, you can only have one set of rules to govern who elects the directors. So, for example, if you're playing an NFL football game, you have to have one set of rules. Both teams comply with the rules. All right. If you have California rules for corporations and you have Delaware rules for corporations, the corporation has to know, do I have to comply with Delaware or with California? The traditional rule in corporate law is when it comes to the composition and the election of the board of directors, that's known as an internal affair, and internal affairs are governed by the state of incorporation.
So that wouldn't be a problem if Delaware had enacted something like SB 826, because that's where the corporations are chartered, are incorporated. Is that what you're saying on that particular issue?
That's another A+. That's exactly
I feel
right.
so much better because unlike the two Joes, not only don't I teach corporations, but I didn't take corporations.
See, it's not that hard.
I feel better now. Well, we'll be back with more from our guests, Gail Harris and Joe Grunfest, talking about corporate boards of directors and diversity, next on Stanford Legal on Sirius XM. Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Joe?
Pam, before we took a break, we were talking about the constitutionality of this new California law, and our colleague, the other Joe in the room, Joe Grunfest, took us through the argument the law violates the so-called Internal Affairs Doctrine. I want to look at the other source of possible unconstitutionality, which is equal protection. And Pam, there I'm going to ask you to talk about it a little bit.
So I'll just lay out the Equal Protection Clause. Both the California Constitution and the U.S. Constitution have equal protection clauses. And these clauses say essentially that the state can't deny equal protection to anyone inside the state. And the way that both equal protection clauses have been interpreted by the courts is that if you want to use a characteristic of people like people's sex to decide who gets a benefit or who faces a burden, you need to have a very persuasive justification for doing this, that presumptively you're not supposed to take people's sex into account or their race into account in deciding benefits and burdens. And the U.S. Supreme Court held in a case actually that came out of California that involved the University of California at Davis Medical School that quotas are an especially constitutionally suspect way of regulating benefits and burdens. So against that backdrop, there's a question about the California law, which, as both Joe and Gail have said, imposes a quota on corporate boards. So, Joe, what's your view? I mean, right before the break, you said you thought this was the most successful unconstitutional law in history.
Well, that's right. So with regard to unconstitutionality, I feel on firm grounds when it comes to the internal affairs doctrine. When speaking about the constitutional principle of equal protection in the presence of Pan Carlin, I am humbled and I am, struggling for words out of fear that I might say something that's not precisely correct. So let me take the chicken way out, and I'm just going to agree with Pam that the probability that the courts will hold this legislation, which is in effect a quota with regard to the number of women on corporate boards, the probability that this will be constitutional under either the California or United States Constitution is, I think, relatively low. Would you agree, Pam?
Yes, I would give you that A+ that you gave me. I would just return it right to you.
There you go. So this is how the cartel actually winds up working on the faculty here at Stanford Law School.
So,
I mean, it's kind of interesting because if California, California had a case that went up to the California Supreme Court a bunch of years back called High-Tech Wireworks that involved the question whether under California law, California employers could even deliberately recruit only people of a particular race or like. And the California Supreme Court said even that kind of recruitment was constitutionally problematic.
I note that at the federal level, one attempt to increase diversity is with respect to people, big companies that contract with the federal government. But there, the rule is only that you have to have an affirmative action plan. There's no quota. This would be a little bit more like the state of California saying that universities have to admit a certain percentage of students from a certain race.
Yeah, which is clearly unconstitutional. That's what Bakke held. It was a plan that said of the 100 seats at the University of California at Davis Medical School, 16 of the 100 seats would be set aside for members of underrepresented minority groups, and the Supreme Court held that's unconstitutional. You can take diversity into account, but what you can't do is have a deliberate set-aside of a certain percentage of the available seats. And if that's true for a medical school, I would think a fortiori, to use a pompous legal phrase, but even more so it would be true for a corporate board.
So this is kind of an interesting situation. It's where our state legislators have done something which, I don't know how you feel about this, Pam. We talked a little bit about it before our podcast. Offends me a little bit because they're adopting something as a law that violates the Constitution or is almost certainly going to be held to violate the Constitution. On the other hand, they hit it correctly and maybe it worked. Gail.
I certainly would never question Pam on a constitutional matter, and I wouldn't even question Joe to that on a constitutional matter. But I do agree with Joe that if it is unconstitutional, which it certainly sounds like it is, it has been a really successful unconstitutional act. Think about it. One of the reasons that boards, I think, don't have more women on is because it's a little bit like an old boys network. People look at their network. And if you have a group of men sitting around saying, we need another board member and we want somebody who has this type of background, they'll come up with a list that's from their community. And when you have more women in the room, that certainly expands that possibility. But by having this law, it forced everybody to look outside. It raised the awareness.
This is Stanford Legal, and today we're talking about diversity on corporate boards with Gail Harris and Joe Grunfest. And Gail, during the break, we were talking a little bit about just how even one woman in the room can disrupt that old boy pipeline. I wonder if you might say a little bit about that.
Well, I think that's certainly true. I chair a governance and nominating committee, and it's certainly foremost on my mind. But I think we should give a little bit of credit to places like BlackRock, ISS, State Street, Glass Lewis. they are also, although they're not putting numbers to it in most instances, they're backing diversity. And by diversity, I don't mean just women, because I think Joe's opening comment is boards should have a broad range of diversity. So I think this has raised awareness, and frankly, it's given them a little kick in the pants.
For those of our listeners who don't kind of recognize BlackRock and ISS, these are companies that hold huge numbers of shares in other companies.
And they get to decide how those shares are voted. So they're coming out and they're saying in certain instances, unless you have some woman on the board, unless you have appropriate diversity, we may withhold our vote for the person who is leading, chairing the nominating governance committee, or maybe even the whole board in certain instances. But having said that, in the case of California, by putting the quotas in, as Joe said, we now have many more women. Even if it's declared unconstitutional, I would call it a success.
Because it seems unlikely that those corporations are going to want to go back to all-male boards, right?
Absolutely.
Yeah.
Absolutely. If it's declared unconstitutional, they're not kicking the woman off. And also, remember the larger companies, the ones that are really in the public eye, they have much more incentive to get women on the board because they are in the public eye. There's a lot of incentive on their part to diversify their board, and because they're just, they can't hide. You've got a lot of smaller companies, I think, that are really the ones that will be tougher to move without a quota system.
And are those small companies, Gail, subject to the law because they'd have to be publicly traded? Isn't that right? Are there enough small publicly traded companies?
Well, I'm talking small and mid-cap,
Okay.
the ones who aren't really, in the public eye. I would say, we're always reading about Apple and Google and, the big banks, J.P. Morgan. So those clearly don't want the bad press associated with it. And I think they actually are becoming convinced that there might be something to it to have women on board.
Well, we've been talking with Gail Harris, our alum, and a board member, and our colleague Joe Grunfest about the new California law that requires publicly traded companies headquartered or organized, chartered in California to have women on the board. The consensus is, on the one hand, the law is unconstitutional. It's California horning in on Delaware's right to govern the internal affairs of companies organized in their state. It's unconstitutional because it's a quota. For the same reason, it would be unconstitutional for the state government to tell you how many people of a certain race you could have. And yet, the law seems to have worked. We're getting more women on the board, and the old boys network is, if not crumbling, it's being eaten away at.
So thanks, Gail, and thanks, Joe, and thanks to our listeners for joining us on Stanford Legal here on Sirius XM.